Good afternoon to all of you tuning in on the East Coast. Good day to the rest of you from wherever you may be finding this program. We're glad you're with us. It is March 19th. We are just about at spring. The flowers are certainly beginning to blossom a bit here in New York City, where I'm speaking with you from. I saw that in Washington, D.C., the cherry blossoms are out. So we're definitely at a moment of a change in seasons. And we want to, of course, make sure that we use this time with you today to give you an update on things that are topical in the legal world that we're hopeful you'll find useful. And so with that, Kathy, I would love to walk through the agenda, which will be on the next slide. Thank you. So I will be talking with you about what is keeping many of us in the government space busy right now. It's an area where I speak to you from pretty regularly on this program. That is the budget in New York State, which is moving forward to a completion on or about April 1st. I'll get into those details in just a moment. After I speak, Sam Brewster, who is with us for the first time on the program, will be discussing a federal court case, or essentially federal court activity in Texas concerning NLRB joint employer rule. Interesting stuff, important stuff. Kamisha Parkins is back on the program. She was just with us earlier this month, and now we'll be tackling a slightly distinct topic, this time talking about financial value transparency in the context of the U.S. Department of Education. James Loria is back on the program for the second time. His first presentation was in the fall of 23. We're grateful that James is with us, coming to you from our Melville office. And James will be addressing New York State's analog to the Federal Corporate Transparency Act. There's some important stuff happening in New York State that all of you with ties to the state will want to know about. Jennifer Sin is back on. Jennifer, a regular from Albany, will be discussing this time around tenant disputes and abandoned premises. I will then take your questions as we close out the program. So, Kathy, if you wouldn't mind turning to the next slide, please, let me turn to my brief remarks concerning the budget. I signaled that we're getting close, and let me explain what that really means. I know last week, a week ago today, you would have heard from Kristen Smith talking about the various elements within the One House bills, and there's still a lot of work that is taking place among the two legislative bodies and the executive branch to essentially untangle all of that and come into position of agreement where that is feasible before April 1st. This is the week where really the core negotiation is beginning on the budget from everything that's being reported and that otherwise we know. There are some major sticking points, particularly in healthcare. We've talked about some of them before relative to Medicaid funding, relative to the Consumer Directed Personal Assistance Program is just two examples. There are questions around essentially reimbursement rates in the One House bills. There are substantial differences in the approach that the legislature would take in terms of healthcare entities and what it would be to reimburse them for their services. So there's a lot of divide there to overcome. We'll also be tracking in other industries, including, for instance, education, what's going to happen with, again, very significant changes in funding structure that others have previously discussed in presentations earlier this month, so I won't unduly focus on that now. Point is, the rubber is meeting the road in these next couple of weeks, and we will, as a team, keep you apprised. And so more to come there. But before we get to that point, let us walk through the next component of our agenda, please. And I will introduce you, if Kathy, you wouldn't mind advancing the slide, please, to our next speaker. And that is Sam Brewster. Sam is with us for the first time on the program, as I noted. And Sam, in specific, is someone who brings a background in labor and employment, working with employers on a variety of such matters, including federal laws, Americans with Disabilities Act, Age Discrimination and Employment Act matters, Title VII, and a variety of other elements that all roll up into Sam's portfolio. Sam did his undergrad at Stony Brook, down here closer to the city, and was a law student at Syracuse and joined Bond thereafter. We're delighted that Sam is with us, and welcome to the program for the first time. We're hopeful this will not be your last visit, and we're looking forward to learning about what's going on in this Texas federal matter. So please bring us up to speed, Sam. Thank you.
Sure. Thanks, Gabe. Appreciate that. Hi, everybody. Sam Brewster. I am an associate in Bond's Labor and Employment Group. And so today I'm going to be speaking about a court decision out of the Eastern District of Texas that struck down the NLRB's new joint employer rule for purposes of the NLRA. And Kathy, if you'll go ahead. Yep. So on March 8th, Judge Campbell Baker out of the Eastern District of Texas granted summary judgment and struck down the NLRB's new joint employer rule, which the board adopted in just 2023. The action was brought by the U.S. Chamber of Commerce and a coalition of business groups challenging the rule's lawfulness. And the challenge really was under the new rule, employees are more easily deemed joint employers for purposes of the National Labor Relations Act. And the judge found that with that new broad structure, the rule was actually overbroad, and it failed to create a clear standard for employees that they could follow. And Kathy, you can go ahead. Thanks. And so when we talk about joint employment under the NLRA, this rule that was challenged had to do with whether an entity qualifies as a joint employer for purposes of the National Labor Relations Act. So it's not tort liability, not consumer liability, but whether the entity has an obligations and duties that are placed on it under the NLRA. And so the NLRA does impose significant obligations on employers in dealing with their groups of employees. So some of those are the duty to bargain in good faith with the employee's bargaining representative, i.e. their union, over the essential terms and conditions of employment. It also includes a duty to furnish information upon a union's request, and then a duty to refrain from interfering with employees exercising their rights under the Act. What's important here is under the new broad rule that the NLRA does not distinguish between an employer and a joint employer. So if under this new rule, an entity qualifies as a joint employer, it is subject to the same duties, obligations, and penalties as any other ordinary employer under the National Labor Relations Act. And Kathy, we can go ahead. And so this new rule, as I mentioned, it came out in 2023, issued by the board in October. It had an effective date originally of December 26th, but after some pushback, the board actually extended the effective date to February 26th, 2024. And then upon this action in Texas, the Texas court actually extended it further until March 11th, 2024, pending the outcome of this case. And as I mentioned, the rule makes it easier for entities to qualify as joint employers under the National Labor Relations Act. And it did this by replacing what is traditionally an employer needed to exercise direct and immediate control over employees in order to qualify as an employer. Now that's been replaced where in an entity that exercises either indirect or even potentially could control but didn't exercise that control could still be found to be joint employers. So under this new rule, there was a two-part test that found that an entity is a joint employer for purposes of the National Labor Relations Act, where it qualifies as a common law employer, which simply stating means that that entity has the power to control the material details as how the employees perform their work. And so long as an entity qualifies as a common law employer, it would be a joint employer if it controlled one or more essential terms and conditions of employment. And those essential terms and conditions are set out in the rule itself. There's 7 that are enumerated, but they're generally going to be your wages, benefits, compensation, hours. And in this case, one of the enumerations was work rules that govern the manner and means by which the employees perform their work, which if you hear sounds a lot like that first step of what you needed to qualify as a common law employer. And the court points this out. And Kathy, we can go to the next slide. And so another part of the rule in a later section, it sets out 2 broad propositions that seemingly bypass this two-part test for joint employment status. And it basically says if an entity satisfies either of these circumstances, they're a joint employer. So the first of those is whether the entity possesses the authority to control one or more of the essential terms, regardless of whether they exercise that authority. So simply having the potential, either contractually or otherwise, to control one of these terms, that entity would be deemed a joint employer. The second one was whether an entity does exercise control over one of the terms, the essential terms, whether directly or indirectly, they're deemed a joint employer. And so what this opens is now entities that could potentially control one of the essential terms, so impact the wages, hours, anything like that. If they could potentially do so, then they're joint employers. But even if they indirectly could affect wages, hours, anything like that, they're going to be deemed joint employers. So Kathy, the next slide, please. As the court points out, this is too much, this is too broad. And so the court grants summary judgment for the U.S. Chamber of Commerce and really bases it on three main conclusions. The first one was the two-part test that the board set out for practical purposes is one step. Because if you are a common law employer and you have the power to control the manner and means by which employees perform their work, then you necessarily satisfy that second step in that you do control one of the essential terms, which is the manner and means by which employees perform work. The second conclusion was that these broad propositions that seemingly bypass this two-part step is overly broad, in that when you allow an entity that could potentially control essential terms, but never exercises that, and that if they could potentially but do it indirectly, it would apply to virtually any entity that contracts for labor, whether they exercise any direct or immediate control over those employees at issue. And the court says this is overly broad. And then third, this interplay between the two-part test and these broad propositions, the court points out, it just fails to create a clear standard for employers to follow in the future. And so Kathy, we can go to the next slide. And so what this decision really does at this point is nothing. It kind of extends the effective date by which this rule may be implemented at some point, but surely extends it obviously past March 11th. But as far as foreclosing future litigation, it won't do that. It'll be seen whether the board wants to take a step back, rewrite potential provisions, but the board may also choose to appeal the decision to the Fifth Circuit. On kind of catting on to this, around the same time that this action was filed, the Service Employees International Union filed a petition in the DC Circuit Court of Appeals seeking to strengthen the rule. They wanted to add more essential jobs terms and conditions to the rule itself to actually strengthen it. So at this point, the decision is not going to foreclose any future litigation in the coming months. Many things may come up, and we'll do our best to make sure we're abreast of those and keep everyone updated. But I appreciate everyone's time. Thanks.
Sam, thank you. That was very instructive. And obviously, this is an area where there is a significant amount of movement. It involves many of those who are tuning in the context of your employer relationships. And so we will keep you apprised. And we, again, are thankful, Sam, that you were able to come on the program for the first time, and please come on back. So let's move to our next speaker for the afternoon, who will be Kamisha Parkins. I will be supervising Kamisha today. And Kamisha, this time around, will be discussing the U.S. Department of Education requirements concerning financial value transparency. This is something that is important, particularly for those of you tuning in who have ties to higher education, and we wanted to make sure you got the news hot off the presses. So Kamisha, please, welcome back, and I look forward to learning along with the rest of the group here.
Yes, thank you, Gabe. Good afternoon, everyone. Kathy, you can go to the first slide. Yes, so I want to kick things off with some background. So in October of 2023, the U.S. Department of Education formally published regulations related to gainful employment, just to address concerns about educational programs that prepare students for gainful employment in a recognized occupation, but unfortunately instead leave students with unaffordable debt in relation to their earnings. And so these regulations do include a financial value transparency framework. I will be referring to it as FVT framework throughout the presentation. And this framework was designed to require all post-secondary institutions to provide students with an estimate of out-of-pocket expenses necessary to complete these programs at any particular institution. Next slide. The financial value transparency framework does go into effect on July 1st of 2024. So starting July 1st, institutions of higher education will be expected to report the estimated costs of any particular program. This includes tuition, fees, books, and supplies, the estimated costs pertaining to non-federal grant aid, the estimated loan burdens, and that includes private and federal loans that students may take out, the typical graduate earnings that students are left with following graduation from these programs, and the estimated costs related to applicable occupational and licensing requirements. And so the purpose of reporting this particular information would be to give students an idea of what they are likely to pay out of pocket for enrolling in any particular program, how much debt they can expect to take on, and what they can expect to earn post-graduation from these programs. Next slide, please, Kathy. So the programs that are required to report this FVT information does include undergraduate, certificate, and graduate programs at post-secondary institutions, which participate in Title IV of the Higher Education Act of 1965. And to put that in, simpler language, programs that are eligible are those that lead to a degree or certificate, or those programs which prepare students for employment in any recognized occupation. Next slide, please, Kathy. So students can expect to access the FVT information from a program information website that will be designed and maintained by the Department of Education. The website will be made available to all students. And there will be an acknowledgement requirement for students who are particularly in certificate and graduate degree programs. What this acknowledgement requirement will ask of these particular students is to acknowledge having seen the FVT information on the website, and this requirement will have to be done before such students enroll into these programs. And undergraduate students are exempt from this acknowledgement requirement. This is intentional by the Department of Education. The Department of Education has explained that they are focusing on certificate and graduate degree programs because they are the programs where unaffordable debt is most common. The Department of Education has not yet provided a time frame for when this program information website will be complete, but it is likely to be within the next year since the acknowledgement requirements will go into effect, they suspect around 2026. Next slide, please. So the Bond Higher Education Group is actively tracking these regulations for additional guidance, and we do hope to provide more detailed guidance on this issue once the Department of Education makes this reporting website publicly available. So definitely stay tuned for further updates. Thank you.
And Kamisha, thank you. Of course, we will have you back for those further updates. And I should note that Kamisha is just around the corner from me here in New York City. And Sam is with us from our Syracuse office, each of them contributing to the program, from our different bond branches in New York State. So we're grateful that both Kamisha and Sammy had the opportunity to contribute. Let's turn now to our third speaker for the day, who will be James Loria. As I noted earlier, James is here from Melville. And I wanted to also remind the group that James was on the program once previously in the fall of 2023. And at that time, James addressed Corporate Transparency Act matters and brought all of you up to speed essentially on what was happening at the federal level. There are now some changes in New York State that are functionally analogous that we thought all of you should hear about. And James was gracious enough to make the time to come back onto the program. So James, thank you for that. And I look forward to learning. Please go right ahead.
Thanks, Gabe. I appreciate it. We can go to the first slide here. Great. So like Gabe mentioned, in the fall of last year, I spoke on the Corporate Transparency Act, which took effect in January of this year. And because of the similarities between the new New York law, which we'll get into in a little bit, I kind of wanted to do a refresher first on the Federal Corporate Transparency Act, what it is and how Bond as a firm and other attorneys are helping clients comply with the statute. So the general idea of this act is for the federal government is seeking information on the ownership and control of various private entities, whether that be LLCs, corporations, or partnerships, with the goal of deterring money laundering, fraud, and other crimes. There's two kinds of entities that could qualify as a reporting company that would need to comply with both the federal and the New York state law. There would be well, first of all, there's domestic and foreign entities that would have to comply, but you could either have an entity that's already existing prior to this year in terms of the federal compliance. And then those entities have till the end of the year to comply. And entities formed in 2024 will have 30 days. Though given that the statute just came out, the government's offering a safe harbor with more time to comply in case clients and their attorneys and their agents are struggling to get the filings in on time. Many exemptions exist for these reporting companies. I'm not going to go over all of them here today because I want to make sure to save time for the New York law and the differences. I listed some of the more important ones here. Certain larger companies and charities are examples of reporting companies that would not need to file their beneficial owners with the federal government. And for the federal law, you don't need to file anything to be an exempt entity. You would simply not file, and if anything would come up, you would then cite your specific exemption and go from there. And then see at the end of the slide here, there are civil and criminal penalties for not complying with the statute. Though I will say, without getting too much into the specifics of the federal penalties, most of it revolves around intentional misconduct. So purposefully including the wrong information or purposefully avoiding compliance with the law. Next slide, please. The kinds of entities that would have to report are any entities that have to file formation documents with a state in the United States. So this would mostly be LLCs and corporations, some limited partnerships. Most importantly, in the examples that we've seen so far, most trusts do not have to register with a state to form and therefore would not qualify as a reporting company. And then the kind of things that would need to be reported for each of these entities include the information about the company itself, the information about the applicant, which is essentially the person who files the formation document or gives instructions to the person that files the formation document. Often this will be your attorney. I'm often an applicant when I'm helping a client form an LLC in New York. I got my FinCEN, which is the name of the bureau that's helping the Department of Treasury with this compliance. I got my FinCEN number and I can plug it in whenever I'm forming an entity, and they have my information from there. And then most importantly, the entity's beneficial owners are going to have to report information about themselves. Beneficial owner can be one of two people, can be someone who has substantial control over the reporting entity. This tends to be managers. There's a more detailed analysis you can find on the FinCEN handbook and in other, I'm sure everyone can find plenty of information online with more specific details about that kind of definition for a substantial control. But I just wanted to touch on the broad strokes here. The other kind of beneficial owner would be 25% or more equity owner in the company. And this could be an entity itself. If your reporting company is owned by an entity, you're going to have to go down the line of ownership there and report the beneficial owners of the entity down the chain. So this is where these things can get complicated and where we recommend you reach out to your attorney if you need assistance with these kind of things, just to make sure you know who needs to report on behalf of each entity, who owns 25%. And then you'll see on the bottom the kind of information that you have to submit if you're a beneficial owner or an applicant. It's very simple. It doesn't take a very long time to actually do the report once you determine who the beneficial owners are. It's date of birth, your name, the address, and we've had clients submit driver license photos and the driver's license number from different states, and that's been sufficient to submit these reports. Please continue. Thank you. So let's quickly shift to the New York version of this law. Originally signed in December of 2023 with a large amount of negotiation and I believe some kind of stalling by the state government earlier that year. The law was originally intended to come into effective of next year. However, recently in my research for this presentation, I saw that Governor Hochul signed an amended version on March 1st of 2024, which will delay the effect of the legislation until January of 2026. So a little breathing room for the state compliance, though, as you will talk about, it's essentially the same sort of information you're reporting for the federal law. So it's not going to change specifically the obligation generally for these kind of requirements, but the state law is going to be delayed in its effect. The other important part of this amendment in March, and one of the more controversial things about the New York legislation to begin with, was the requirement for New York only, not for the federal law, that there would be a public database for all this information that was going to be provided. However, with the effectiveness of the new amendment, that public database requirement has been removed, and the database will only be available to law enforcement or the regulatory agencies for which entities and beneficial owners are submitting the information. The goal of the New York statute is the same as the federal statute, and I think we're going to be seeing other states slowly come along with this sort of regulatory scheme in the future. It encompasses out-of-state entities who are registered to do business in New York, as well as the LLCs formed in New York. And the kind of submissions you're going to make are going to be the same kind that you're submitting for the beneficial owners for the CTA. So the date of birth, the address, the photo ID. The main difference for the New York statute is that it will only apply to LLCs. The corporations wouldn't be incorporated into the statute. One notable difference that's going to require a little bit more legwork for the attorneys or the clients here is that if you wish to file for an exemption to say that you're not a reporting company or I don't need to file my beneficial owners, New York State's going to require an actual physical document be filed, an attestation of exemption for those kind of procedures. And unlike the federal law, which requires updates 30 days after any of this information changes, the New York State law is simply going to require an annual update, which means you don't have to be as on top of something if it changes immediately, say in January, but you will have to confirm the information is the same come the time of the annual report. Next slide, please. So I just wanted to spend a few minutes talking about how Bond is addressing their clients' questions and needs for the Corporate Transparency Act. And of course, we intend to fully help and comply with the New York statute as well, though that policy isn't as concrete yet in terms of how that's being handled with the firm. I will say, of course, that it's going to be very similar to how we handle the federal compliance. We are encouraging all of our attorneys, whether they're in the corporate department or not, to inquire with our clients about Corporate Transparency Act issues so everyone's aware of these things on the outset of an engagement. Engagement letters themselves are going to include information that if an entity is being formed as part of our engagement, we expect you to provide the correct information and we will help you file the beneficial owner report for the Corporate Transparency Act. Or if the firm is not going to be helping, we will make sure to at least instruct the client that they need to be handling that filing themselves. Bond has created an attorneys committee for the Corporate Transparency Act. I'm a part of that committee. And our job is to assist the non-corporate attorneys or the people who are not on the committee with their clients for complying with the statute and to help oversee anything that's going on. So sort of resident experts in the firm to help comply with this law and prevent any issues. Each client that forms an entity with us is going to receive a beneficial owner certificate, which is essentially going to be what goes into the beneficial owner report that is formally submitted to the federal government. And that'll have the kind of information like, date of birth and address and photos of the license. So we have everything in one spot and the client can rest assured that we can create the filing for them. Or if they wish, we can send them the certificate and they can do the filing. And then of course, logging all that information on our system and reaching out to past clients about their pre-existing entities that existed before the federal statute took effect and before the New York statute will take effect. Hey, your entity is going to need to comply with the Corporate Transparency Act. Here's the information we have. Can we submit it on behalf of this existing entity? So those are some of the efforts that Bond is taking to seamlessly incorporate this federal statute and the compliance into its normal relationship with its clients. And from personal experience so far, it's gone pretty smoothly. It's just a matter of collecting information and none of it is too onerous once you determine who the beneficial owners are. Next slide, please. Thank you. The last point I wanted to bring up today was sort of one potential thorn in the side of the state compliance that I've been thinking about and some clients have asked us to research. Many entities formed in New York and in other states are formed for the purposes of owning property. And the question is, if my entity is just there to own property for me, am I going to need to comply with all these transparency laws? And is this information going to be publicly available, which obviously would not be appealing to many of our clients? The governor's signing of the new amendment does indicate the resistance towards that public database and the removal of that requirement from the New York statute. And the fact that it doesn't exist in the federal statute should alleviate many of those concerns. But that being said, even out-of-state entities who do business in New York, who own property, are likely going to have to comply with these transparency laws. Because in New York State, while it is unclear and has not been fully litigated, the act of owning property in the state, even by itself, and the process you have to go through to buy land in New York, normally will qualify as doing business in New York State. And so existing entities formed for the purpose of owning property would most likely, though I do expect this issue to be expanded upon and challenged potentially in the future, would qualify as reporting companies that would have to comply. So that was just an issue that I saw coming up and one that might be discussed in the future of what to do with those kind of entities. I believe that's my last slide. So thank you for the time today.
James, thank you for coming back onto the program and for providing this really instructive update, weaving in what we know about New York, what some of the negotiation led to being hailed in versus carved out. And I look forward to, as we move forward relative to the federal implementation, getting you back on the line if there are things that we're hearing about from our clients with regard to their interactions that would be useful for this broader audience. And let me encourage all of you who are listening who have an inkling now, having heard James present, that maybe we should be paying attention to CTA, please to reach out because we want to be helpful there. Let me turn then to our last speaker for the day, who is Jen Sin with us from Albany. I needn't provide Jen with an extensive introduction because Jen is a regular on this program, but all of you are familiar with the fact that Jen has a really interesting and varied practice that includes hospitality, transactional activity, and a variety of other facets. And today, Jen is here to discuss tenant disputes and abandoned premises activities that she's seen in her practice and that she thought would be instructive for this broader group. So Jen, thank you for coming back on the program.
Good afternoon. Thanks, Gabe. Thanks for having me back. Always happy to participate. And as Gabe mentioned, so in addition to my general corporate work, I do real estate and transactional work, and I do a lot of liquor licensing. So like to join every so often, give some updates on alcohol. I realize that some of you aren't in the alcohol service industry, so I'll try to keep it brief. But something that has come up in my practice, as Gabe mentioned, comes up a lot in transactions, and something that the Liquor Authority has put some updates out on has to do with abandoned premises and surrendering liquor license. So the general rule in New York is that you cannot have two liquor licenses issued to two different entities or people for the same physical space. The Liquor Authority calls that the licensed premises. There are a few exceptions. Some manufacturers do what's called alternating premises, but generally speaking, that's the rule. You can't have two liquor licenses issued to two different entities for the same place. And that becomes very important when you're having a transaction. You're buying the business, you're buying the real estate. You can't have those licenses overlap in time and space. So that's the reason why the Liquor Authority requires that the current licensee surrender its license before it will issue a new license or a temporary retail permit to a new applicant for that same license premises. So like I said, that's going to be very important when the applicant or the new applicant is buying a business, it's buying real estate from a business that had a liquor license in that space, or if the applicant is a new tenant for a space where the space used to be leased to somebody who had an alcohol-related business. In all of those cases, we do need the old liquor license to be surrendered. So sounds pretty straightforward, but in practice, run into all kinds of issues. For example, what if the current licensee won't surrender the license? Had that happen. That can hold up a closing in a major transaction. What if you can't locate the old licensee? That happens too, unfortunately. Or what if one owner of the licensed business is willing to surrender, but the others aren't, and there's a dispute between owners of the existing licensee. It seems like such a ministerial thing to surrender a license. You take the certificate off your wall and you sign the back of it, or you sign a one-page what's called petition for surrender. Seems very simple, but it ends up sometimes being a pretty big issue. Sometimes I also get calls from landlords whose tenants are falling behind in the rent. They're looking to get out of their lease, or sometimes they've even abandoned their space. What do we do now? We've got a new tenant. We're looking for a new tenant. New tenant's willing to come in, wants to take over operations of this restaurant or this bar, or whatever it might be. Are they going to be able to get a liquor license because the old tenant is not cooperating or is missing, and we can't get them to surrender the license? So the Liquor Authority had seen an uptick in that, had addressed this problem in a public advisory, and they've created this new mechanism for an applicant to get a license in a case where the current licensee can't be located because they've abandoned the premises. So how it would work is this: the new applicant, gets an affidavit from the owner of the real property indicating that the current licensee has abandoned the premises. Submit that affidavit. There's some supporting documentation that goes along with it. You submit that to the Liquor Authority, and the Liquor Authority is going to contact that current licensee by certified mail and or email. And they're going to see if that entity, that current licensee, disputes that claim of abandonment. Now, if the current licensee disputes the abandonment and tells the liquor authority that they believe they are still entitled to operate in that space, whether that's accurate or not, if they do dispute that, unfortunately for the new applicant, that liquor license application is going to be denied, and we may end up having to file suit against that tenant, et cetera. But if the current licensee acknowledges that they have left the space, they've left that premises, or, and this part is key, if they don't respond at all to the liquor authority, now the liquor authority will consider that premises to be abandoned, and it will proceed with its review of the new liquor license application. So very important for some of our folks who are coming in to take over new spaces. We also sometimes have the situation where the owners of the business are having a dispute amongst themselves, where one won't agree to surrender the license. Sometimes that comes up where there's been infighting amongst the owners, and some of the owners want to start a new separate business within that same space. How is that going to be handled? And again, this is something that I think had come to the liquor authority's attention on several occasions, and they've put out an advisory about how they will handle these kind of situations. And that advisory states that any individual listed in the liquor authority's records as an officer of a corporation can surrender the license. If the licensee is an LLC, any individual listed in the liquor authority's records as a managing member, manager, or officer can surrender the license. If the liquor authority doesn't have any of those folks listed in their records, then any member can surrender the license from the liquor authority's perspective. And in this advisory, the liquor authority has explicitly stated that they will not become involved in disputes between the principals or other parties as to who was authorized to surrender a license or not. So a few updates that the liquor authorities put out on some of these issues that hopefully for our folks on the session won't become relevant, but important to know if it ever does. And that's it for me.
Jen, thank you for coming back on the program to provide those updates. We always look forward to hearing from you. And let me now move to the final elements of today's program. Of course, we're happy to answer your questions, whether you have them now or otherwise, you can reach out to us. But I wanted to flag for you upcoming events that are annual for us as a firm and that are ones we really hope you take heed of and otherwise are able to join. For those of you in the space involving labor and employment, we have our annual labor, employment, and human resources conferences across the state. We look forward to hosting you in the region that makes most sense for you, that's nearest by. As you see here on the slide, we'll be doing the work of training and teaching you starting in April and extending through June. And as we get more details here, we'll make sure that all of you get them. So please stay tuned, and we look forward to having more information on a future program. And with that, let me just make sure that all of you have the details for how to reach us, including if you have questions for any of us, you can email. That's always most welcome. Kristen Smith will be back with you on the 26th. And in the interim, wishing all of you a really terrific entry into spring. And I will see you in April. Be well.